Okay, all right. Sorry for the false start, but let me say hello again. I'm Michael Waldinger, Professor of Sociology at UCLA, Director of the Center for the Study of International Migration, and I'm delighted to welcome you to today's session, which we are co-sponsoring with our friends and colleagues at the Center for Comparative Immigration Studies at UC San Diego. So today is the fourth in our session of a series of book talks, brand new cutting edge work on migration. We will have one more such talk to take place on Friday, December 3rd, discussing two very interesting works, Crossing, How We Label and React to People on the Move by Rebecca Hamlin, a political scientist at UMass Amherst, and a book by a very interesting French sociologist. The title I'm translating is Asylum and Exile, A History of the Distinction Between Refugees and Migrants. And actually, I'll be the commentator. We have then a different event taking place Friday that CCIS and CSIM are co-sponsoring along with a number of the other migration centers in the UC system. And this is our effort to respond to the exigencies and difficulties created by the unusual situation that we've all lived through for the past 2 years. And so we've organized a series of workshops, one a quarter, all of which are oriented towards methodological issues and problems that graduate students are likely to encounter in launching their own research projects, whether at the MA, PhD, or en route levels. And the first such workshop will be directed by Professor Marjorie Orion at the UCLA School of Education on the topic, hold on a second, excuse me. Marjorie is here. So on flexible approaches to ethnographic research during a global pandemic. Sorry, Marjorie is here in the session. So I'm gonna just pass the floor to her for a moment to talk about the workshop, and then I'll turn the floor over to our author and our discussant. So, Marjorie.
Yes, please join us if you can. We'll have miraculous answers to this challenge of how to be flexible and do ethnographic work during times of lockdown. No, we won't, but we will share ideas, workshops. It's a workshop, so make sure you fill out the 3-question survey that Warren will send you when you register for it, so that we can have an idea of who's going to be there, what questions are on your mind, and what stage of work you're in and what kind of work. And we'll do some breakout rooms to share among ourselves and hopefully get energized for the challenges of field work during this time.
Terrific. Okay, thank you so much. So that'll be next Friday from 12 to 2. Okay, so today I'm delighted to welcome Jane Lilly López from the Department of Sociology at Brigham Young University, who will talk about her new book published by Stanford University Press, Unauthorized Love, Mixed-Citizenship Couples Negotiating Intimacy, Immigration, and the State. So Jane will talk for roughly 20 minutes. She'll then be followed by Irene Vega from the Department of Sociology at UC Irvine, who will offer a 10 to 15-minute comment. Jane will respond, and then we will segue to Q&A with the audience. The easiest would be if you raise your hand, and then I will call on you, and you should be able to direct your question to the author or commentator directly. Okay, Jane, the floor is yours.
Thank you so much. I was under the impression that I'd have 25 to 30 minutes, so I'm going to try to keep things short, but
take all the time you need, no problem.
Okay, thank you. Well, it's wonderful to be here. This is my it's a bit of a homecoming for me, as I did all of my graduate work at UCSD and was a regular at CCIS meetings like these. So it's really wonderful to be here. Thank you so much to Roger and David for this invitation, and to everyone who made this possible. I'm also excited to be doing this over Zoom so that other people who couldn't have been there in person can join us. And I'm really excited to share this work with you. And I wanted to start by explaining why I started studying mixed citizenship couples in the first place. And I'll also give a quick note. I struggled with what kind of photographs I could use in a presentation, given that I have to protect the identities of the people that I study. And on a recent trip that took me to the border wall, these three pigeons came and spoke to me and told me that I should take their picture to represent myself and my two close friends whose stories motivated the research for this project. So you'll see photographs of the border wall, and they are here to remind you both of the physical border and the separation that it creates, but also the symbolic separation that it creates in the lives of many families and friends living within and outside of the United States. So here, these three pigeons are Camille, Juliet, and I, who in 2009, we all fell in love with non-citizens. Giovanni, Camille's future husband, came to the US from Guatemala when he was just 6 years old, and they felt a spark as soon as they met. Giovanni's parents and siblings had been able to obtain a legal immigration status, but Giovanni was too old to adjust to a legal status under his parents' naturalization when they were able to access legal status and later citizenship. And so he had no authorization when he came to the US and when he and Camille fell in love. Camille was not too worried about it though. She figured that once they married, he would automatically qualify for citizenship through her. Tenoch, Juliet's partner, came into the US without authorization in his early 20s, shortly after his mother died. In Mexico, he had been studying at university to be a chemist. In the US, he began working in construction to help support his father and 11 siblings back home. My boyfriend, Ramon, still lived in his Mexican hometown, conveniently situated on the border with California. He had a tourist visa and could travel back and forth regularly to the US as needed, although Mexico remained his country of residence. When we fell in love, and in 2009 and 2010, as Camille and Juliet both got married and Ramon and I got engaged, we all felt like our lives were just beginning as fate beckoned us toward a future full of promise. But by the time I began my doctoral program in 2011, Camille and Juliet were both married with babies and I was newly engaged. While we felt like we were heading down the same happy path, our partners' different legal statuses were already pushing our lives in different directions. Police had arrested Giovanni in late 2010 on a warrant after pulling him over for speeding. He spent a year in jail and was slated for deportation as a result. Camille gave birth to their baby boy alone, and now she was fighting off depression and caring for her newborn while exhausting every possible lead that could help cancel or delay Giovanni's deportation. Juliet experienced stress and anxiety as she adjusted to her new life in the shadows as part of an unauthorized immigrant family living in the US. She had nightmares that police were pounding on their door, calling out Tenoch's name, waiting to arrest and deport him. Most days felt normal as life with a newborn can feel, but Juliet also carried with her a new never-ending worry that quietly gnawed at her peace of mind. Every day she wondered, will today be the last day our family can be together? And yet everything for Ramon and me seemed straightforward. We could marry when we wanted and live where we wanted, which for the time being would be in Mexico. We both traveled freely between the US and Mexico, building ties as a couple with family and friends in both of our countries. The world was as wide open as we wanted it to be. Our opportunities seemed endless, and we felt uninhibited in charting our future together. As I began my graduate studies, I sought answers to explain how Camille, Juliet, and I, all US citizens, all in love, all equally deserving of family success, could already be traveling along such varied trajectories because of our partners' non-immigrant statuses in the US. Our three stories and our very different experiences within the US immigration and family reunification system have grounded this research from the beginning, setting me on my path to understand why US immigration laws have made it relatively easy for some families like mine to succeed while making it nearly impossible for other families like Camille's and Juliet's to survive. This book is my attempt to both answer these questions and to bear witness to the consequences of US immigration policies on families, a record of our unauthorized love. I conducted my first interview for this project with a mixed citizenship couple during the spring of 2012, just as the presidential election season was getting into full swing. In June 2012, President Obama signed an executive order that made applying for family reunification less of a risk for unauthorized couples living in the United States. In 2013, the US Senate passed a comprehensive immigration reform bill and repealed the Defense of Marriage Act, giving married same-sex couples access to family reunification for the first time. In the early months and years of this project, many mixed citizenship couples I met felt optimistic about the future of family reunification and immigration policy in the US. Although they all confronted challenges, they were still hopeful. I was too. To say that things changed does not capture how dramatically our hope transformed into despair over the next 8 years. The comprehensive immigration reform that seemed possible in early 2013 became very clearly impossible by the fall of that year when the House of Representatives failed to pass the bill. This policy failure marked a shift in the political and social mood around immigration and immigrant families from concern to disinterest to disdain, culminating in the 2016 presidential election. The new administration's obsession with criminalizing immigrants and closing every door to legal immigration gave the stories I share in this book an urgency I had never felt before. Of course, the punishments mixed citizenship families face were written into law long before the 2016 election. The Trump administration's attacks on immigrants and their families laid bare the stark vulnerabilities of both immigrants and citizens under the law. In this legal, political, and social context, it is both my duty and my honor to amplify the voices and experiences of mixed citizenship couples and bring their lives and their love back into the immigration narrative. For this book project, I conducted interviews with 56 mixed citizenship couples between 2012 and 2018. And you can see a brief demographic overview of some of their traits in this slide. Their experiences and perspectives, combined with legal analysis of relevant laws and policies, inform the findings of this project. You'd be hard-pressed to find a US citizen married to a non-citizen who has never been asked the question, so how long before they become a citizen? It's automatic, right? Many Americans believe this is the case. I certainly did. That is why I was baffled and then appalled when my dear friend Camille called to tell me that the US government was deporting her husband, Giovanni. How could this happen, I asked. You're a US citizen. Camille's citizenship, it turns out, was not enough. Not enough to help Giovanni become a citizen, not even enough to save him from indefinite banishment from the United States. The US Supreme Court confirmed this unfortunate truth in Kerry versus Dinn in 2015, stating unequivocally that there is no constitutional right to live in the United States with one spouse. Yet family reunification, an entitlement in US immigration law that enables US citizens and legal permanent residents to extend legal immigrant status to some immediate family members, has served as the foundation of US immigration policy since its inception. This creates a conflict in logic that many mixed citizenship families struggle to overcome. While hundreds of thousands of US citizens successfully sponsor their spouses for legal immigration status with a pathway to citizenship every year, thousands more are denied legal status and any legal authorization to live as a family at all in the United States. Over nearly a decade of searching, I have come to learn that rather than being an exception, an accident, or an anomaly, Camille's experience of governmental rejection and family separation is as central to US immigration policy as family reunification. Every year, the US government rejects the reunification requests of thousands of mixed citizenship American couples based on disqualifying traits of the citizen, her partner, and/or their relationship. From the state's perspective, though, excluded families have not been rejected, nor have any of their citizen members. Family reunification denials only affect unworthy or unqualified individuals, precisely because non-citizenship and unauthorized status are technically individual level statuses. In matters of citizenship and immigration, the state deals with individuals, not families. As the majority in Kerry versus Dinn declared, there is a simple distinction between government action that directly affects a citizen's legal rights or imposes a direct restraint on his liberty, and action that is directed against a third party and affects the citizen only indirectly or incidentally. The government has not refused to recognize the US citizen's marriage to the non-citizen, and the US citizen remains free to live with her husband anywhere in the world that both individuals are permitted to reside. and the government has not expelled the US citizen from the country. It has simply denied the non-citizen admission into the country. Rooted in the individualistic logic of modern citizenship, this decision declares that the citizen's rights have not been affected, as she continues to have free access to her country and her spouse. But the implication of this decision, one that is never explicitly stated, is that a citizen in this circumstance is unable to live in her country of citizenship and with her spouse at the same time. Although the US Supreme Court has confirmed the citizen's right to residence in US national territory, and all individuals, both citizens and non-citizens' right to marry, it maintains that those rights are not mutually inclusive. According to this logic, denying a spouse legal entry to the US or legal status and protection from deportation once living inside the US does not preclude the citizen's access to her country and all the individual level benefits of her citizenship, nor does it prevent her from being able to live with her spouse. The government has simply exercised its right to prohibit an individual from legally entering its territory. Mixed citizenship couples embody a basic yet infinitely consequential conflict for the modern nation state. On one hand, states need families. Families continue to serve as the central organizing unit of society, a key locus through which a state's members are cared for, socialized, counted, and controlled. It is therefore in the state's best interest to recognize and support families whose members include citizens. On the other hand, states want as much specificity as possible in determining which individuals belong. In other words, who they are willing to claim as their own. In an increasingly globalized and interconnected world, states' long-term viability depends upon their ability to identify their members and distinguish them from non-members. This is particularly important given states' increasing obligations to their citizens, including a growing list of civil, political, and social rights they promise their members. Using family rather than individual status to determine state membership could lead a country to formally acknowledge and accept responsibility for individuals it otherwise would not choose to claim. But accepting only some family members and limiting the reach of the related rights and protections granted to those individuals jeopardizes the well-being of citizens and destabilizes the family unit upon which the state remains wholly dependent. The United States has tried both approaches to resolving the individual family citizenship conflict. Spanning from the mid-19th century to the early 20th century, US citizenship law prioritized family over individuality in determining citizenship, automatically granting citizenship to the non-citizen wives of US citizen men. And for a shorter span of time, the US government also automatically stripped the citizenship of US citizen women married to non-citizen men. This approach to citizenship ensured that all family members had the same citizenship status, effectively eliminating the mixed citizenship couple problem, though it obviously created other problems along the way. The individuation of citizenship changed the legal and philosophical relationship between the American state and its members, creating a direct line between citizen and state where once the family served as an official intermediary. While this direct connection to the state brought many significant improvements for newly acknowledged citizens, it did not actually alter the role of the family in mediating the citizen-state relationship. The family remains paramount in shaping individuals' physical, economic, educational, and social opportunities and experiences. But the individualistic framework of citizenship no longer contemplates the family, despite the ongoing role of the family in organizing individuals' daily lives. The consequences of the legal fiction of citizenship and the impossibilities it creates for mixed citizenship families fall most heavily on the families themselves. But the effects of these consequences reach far beyond mixed citizenship families to the heart of society, warping social conceptions of national identity, social interdependency, and who belongs. In the book, I detail how US immigration laws and mixed citizenship couples' engagement with them create unauthorized families whose opportunities and outcomes directly stem from their family level legal status. I argue that rather than some other unique quality of the couples I interviewed, it is the imaginary categories and statuses established in the law, non-citizen, unauthorized, that produce the drastically different trajectories couples follow. Mixed citizenship couples' experiences show unequivocally that our current individual-centered citizenship regime is incompatible with the family. Utilizing data from interviews with 56 mixed citizenship couples, I show that non-citizenship status has family-level consequences that significantly affect the experiences and opportunities of all members of mixed citizenship families. And those experiences and opportunities, in turn, redefine the meaning of citizenship and belonging for citizens and non-citizens alike. This flowchart follows both how the law and individuals' interactions with the law shape outcomes and then the consequences of those legal outcomes with regard to family unification. And I'm just going to briefly summarize or give you a brief overview of each of the chapters and how they relate to this flowchart. So in chapter 1, it examines the normalcy or abnormalcy of mixed citizenship love, courtship, and marriage. In this chapter, I briefly describe 5 mixed citizenship couples' relationships before law intervenes. As they meet and fall in love, their stories seem as familiar and unremarkable as those of other American couples. There is nothing in their love stories that would suggest why some of these couples will face endless obstacles to their continued existence, while others will find the doors of opportunity opened wide to receive them. Inequalities in the law, both as written and as applied, set couples on these divergent paths. And this quote from Angelica, I think, really captures most couples' experiences of encountering the law long after they've fallen in love and decided to commit to each other. We fell in love without knowing each other and our situations really well. And I thought, oh, he doesn't have papers. He voluntarily deported. We can fix that. It was all really easy. We didn't think it's going to take many years. It's going to be very expensive. I'm going to have to live in Mexico as long as he can't cross. We didn't think about any of that. There was simply a connection between us, and our problems have come little by little. The connection was about falling in love, regardless of whether or not it was convenient. Chapters 2 and 3 examine the laws and legal processes, respectively, that determine couples' worthiness for family reunification and their subsequent family reunification outcomes. In chapter 2, I take a deep dive into the 3 laws that currently drive US family reunification policy regarding mixed citizenship couples. Each of these laws has contributed its own modification to the definition of the American family, drawing narrower boundaries around who and what qualifies as family, what legitimate marriage looks like, and what kinds of individuals and families get to be American. Together, these laws have changed the nature of mixed citizenship families and altered American society both substantively and definitionally. Only certain kinds of mixed citizenship families qualify for family reunification under these laws, and families denied this benefit are both figuratively and literally erased from official membership in the United States. But couples' actual legal outcomes do not perfectly adhere to those legal definitions as laid out in the laws examined in chapter 2. Chapter 3 studies why many couples who, according to the law, should or should not qualify for family reunification ultimately experience outcomes that do not align with the law as written. Citizens and their spouses can exercise agency in deciding when to apply, what information to disclose, and how to present themselves and their marital relationships to the US federal government. Because family reunification is citizen initiated, citizens and their families have control in deciding how to present themselves to, sorry, I'm seeing that I repeated myself on the slide, but how to present themselves to government officials, and they only have one chance. So deciding when to apply can ultimately lead to a different outcome for the same couple if they apply at the beginning of their relationship rather than waiting and applying later on. Like a high stakes game of poker, couples' timing, strategy, and expertise, in addition to the cards they were dealt, all contribute toward determining whether or not they ultimately hold a winning hand in family reunification. The law as written, the law in practice, and couples' orientation toward those laws and their enforcement all contribute to families' reunification outcomes. And the long-term, far-reaching effects of those outcomes, for better and for worse, cannot be overstated. I examine the family level consequences of family reunification success, failure, and uncertainty in chapters 4, 5, and 6. These chapters evaluate how family level immigration status shapes individual and family level spatial, structural, and social integration for citizens and non-citizens alike. The logic driving the majority ruling in Carey versus Dinh suggests that actions taken against a citizen spouse only indirectly affect the citizen without meaningfully impeding her individual relationship to her country and the rights and responsibilities entailed therein. But mixed citizenship couples' lived experiences tell a different story. In each dimension of integration, it is law rather than culture, choice, worthiness, or anything else that drives families' disintegration with society. Chapter 4 examines spatial disintegration and demonstrates how it is experienced at the family level. The inclusion or exclusion of one family member leads to the increased inclusion or the exclusion of the family members sharing the same home as a whole. And I find that when families experience a positive family reunification outcome, the citizen and non-citizen spouse both feel more spatially integrated into both of their countries of membership than they did before there was a decision made about their application. Conversely, couples who are rejected in their family reunification bid are excluded literally and figuratively from the communities in which they live, either experiencing spatial disintegration as they are pushed outside of the boundaries of the United States, or spatial isolation where they are limited to movement within certain communities and have to be careful with regard to the ways that they move in the place that they live in order to avoid the threat of deportation. And one couple that I interviewed said, Sonia here told me that when her husband, Sebastian, was having at his deportation hearing, the judge told him, well, you can go and visit him. But as Sonia said, families are not to be visited, they are to be lived with. Chapter 5 examines structural integration and how family structural integration hinges on the ability of all family members to gain entry into economic, educational, and bureaucratic institutions. And in this chapter in particular, I focus on currently unauthorized and formerly unauthorized families' experiences, because for families who have always had authorization to live together in the United States, they have always experienced full structural integration, but the families currently experiencing being blocked out of structural integration, or those who have recently transitioned from not having structural access to having structural access, really demonstrated the ways that structural disintegration permeate every aspect of both citizens and their non-citizen partners' lives. As Eddie, who was a valedictorian of his high school class and a star student in college, realized, he could only go so far as an unauthorized student with no legal status in the United States. Similarly, Trish, whose husband is unauthorized, feels like everything falls on her because she is the only person who has even limited access to these different structures, economic, educational, and bureaucratic, for her entire family. And that was really contrasted with June's experience, whose husband had adjusted to a legal status just 3 months before our interview, when she said, we felt trapped, but now we are free. And in chapter 6, I examine parenthetical belonging or social disintegration. And I find that I discuss how family level acceptance or rejection by the US government shapes individual and family sense of belonging. Again, I see this experience of US citizens whose spouses are accepted in the United States feeling enhanced belonging as individuals as well, such as Julia, who said, we're this great mix of both cultures, both customs, and I think that's the best way to live. It's just a nice little melting pot of love and happiness. She and many others expressed feeling even more representative of the United States as a whole and of the diversity within the United States. Conversely, Christian, whose wife's citizenship application was denied, her green card was canceled, and she was permanently barred from ever having any legal status in the United States, says that even though he lives in the United States still with his wife, he doesn't feel like an American. When somebody asks, I tell them we're an undocumented family. I consider myself rejected by the United States. For citizens whose spouses have been deported or denied legal status in the United States, that third-party rejection mentioned in Kerry versus Din is not incidental at all. It is central to determining every opportunity those citizens can now access and will shape every decision those citizens make moving forward. Spousal rejection not only inflicts emotional harm and suffering on the citizen, but also spatially, structurally, and socially distances the citizen herself from her country and its society. In these chapters, I also find that the family-level disintegrative effects of family reunification outcomes extend to successful families as well. For these families, the formal legal recognition of their family and the extension of legal status to all family members enhances spatial, structural, and social integration for every family member. Family-level disintegration is a dynamic process for all members of unsuccessful and successful mixed citizenship families, moving each family member closer to or further from spatial, structural, and social inclusion. In conclusion, in the concluding chapter, I discuss the consequences of our current mixed citizenship family policy in the United States. And as part of that, my friend Juliet, whose story inspired this research, helped to transcribe some of the interviews that I did. And when she was transcribing the interview of one of the couples who had a clearer path to family reunification than her family did, she sent me a series of text messages, just really in shock, trying to imagine that someone else's experience with the same system could be so different. And here's what she said. Wow, hearing the difference in emotional experience with the system from this couple who seem okay financially and had proper visas through school, etc., compared to mine and that of my friends is night and day. We and my friends had experiences where our husbands had multiple entries and either lost a hard to get visa or never had a chance in hell to get one in the first place. We are all lower income families hovering around the poverty level for our household sizes. She continued, hearing Grace and Lucas discuss the bureaucracy as a nuisance with disdain, but not really otherwise affected, is mind-boggling. I'm currently helping a friend out emotionally as much as possible because she is so afraid. The depression and anxiety that followed me is what I've heard from others. It's so intriguing to see the class difference, education difference, opportunity from home country distant difference, astounding. It's like the United States became the high roller club, and based on the hand you were dealt, you get special treatment. The class-based preferences built into the US family reunification system shape the lives of mixed citizenship couples in dramatically different ways. Punishments directed toward US citizens and unauthorized immigrants from lower socioeconomic backgrounds prevent those families from accessing family reunification. Rather than being a program of family reunification for all Americans and their non-citizen family members, the current US immigration system uses family relationships as a way to facilitate the legal immigration or adjustment to legal immigrant status of middle and upper class citizens and the partners of middle and upper class US citizens. These class-based distinctions are further exacerbated through the process of engaging with US immigration laws, a citizen-driven process that introduces additional opportunities for better educated and well-resourced families to work the law to their benefit and further their systemic advantage. The implications of these inequalities and their consequences for individuals and families cannot be overstated. Unequal access to family reunification and legal immigration status in the US has significant and long-lasting effects on families and their integration. While policymakers often claim that laws directed toward immigrants do not affect citizens, mixed citizenship families' experiences prove definitively that such is not the case. Because family is a central institution through which integration happens, American laws and policies that punish immigrants contribute toward the alienation and disintegration of immigrants and their citizen family members. Denying legal immigration status to the spouses of US citizens is a policy of disintegration, forcing either the dissimulation of the entire family from society or the dissolution of the family itself. Too often we overlook the true consequences of US policies that forced family disintegration, separation, and dissolution. This book is my attempt to bring those consequences back into the foreground. The US's policy of family separation is a choice with significant negative effects for millions of American citizens, their families, and society as a whole. I add my voice to those of others who argue that individualist approaches to social contracts like citizenship fall short of creating systems that properly acknowledge our infinite interdependencies and establishing the conditions necessary to achieve true equality. Mixed citizenship couples represent just one example of this truth. Until we adopt a new system of national membership that prioritizes our social dependencies over hyperselectivity and state power, we will all continue to suffer the consequences. Thank you.
Perfect, thank you so much. So Irene, why don't you go ahead and present your reactions to Jane?
Thank you. Thank you, Roger, and also thank you to the entire CCIS community for the invitation to comment on this wonderful book. I have to be honest.
Turn your video back on, please. Great.
I knew there was something wrong. I didn't know if you could hear me or not see, you know. Okay. So when I received the invitation to serve as a discussant on this book, it felt a little bit like cheating because this is a book that I was looking forward to reading and assigning in my classes anyway. And so here was an opportunity to receive the book early and to really spend time with its arguments and to relish the stories that Dr. López tells so vividly. So this was a real treat for me. Congratulations, Jane, on a wonderful book. I highly recommend it to anyone who is broadly interested in families, in migration, socio-legal studies, and also to anyone who really just wants to read a book that centers the voices of people as they go about living their lives in the shadow of the state and interacting with the state. What I want to do over just 9 minutes or so is discuss two of the book's many contributions, and I want to pose one question about its practical implications, and then a question about theory, and then I'll turn it back over to Dr. López. So first, I think a major contribution of the book is that it challenges us to think about citizenship as a family affair. Dr. López argues that the individualistic logic of modern citizenship is based on a fiction because it denies the very real interdependencies that exist among people across citizenship lines. And by taking a mixed status families as a unit of analysis that capture those fictions, she really powerfully demonstrates how immigration law impinges on what she calls the natural evolution of relationships. For example, the idea that people who fall in love and want to share a life with each other should be able to join their lives and, importantly, have those joined lives be recognized by the state, right? We can probably all think about analogous cases. Or another assumption, which she highlights in her analysis, which is the idea that families should be able to live together in the country of their choosing. So the book is filled with examples that challenge the assumptions we take for granted about an institution that we all feel like we know a lot about, right? The family. So in this way, Dr. López provides a phenomenal example of what Patricia Ewig and Susan Silby call the commonplace of law, or the dominant but often invisible power that laws have to shape our everyday lives and the lives of people that love us and that we love, right? To borrow some of Dr. López's language. So in making this argument about the family level impacts of immigration law, Dr. López makes a related contribution to research that demonstrates how the state and its legal regimes shape the lives and life chances, not just of the people who are the direct targets of law, in this case, non-citizens, but also of those who are, excuse me, connected to them in various ways. So here I'm thinking of sociologists like Cecilia Menjivar and Lacey Abrego, who argue that the modern immigration regime imposes legal violence on immigrants and their families and has intergenerational implications for incorporation outcomes. I think Dr. López's work demonstrates this really powerfully, especially when we think about the children of mixed status couples, whether they live outside of the United States with a parent who doesn't have access to the territory or within the United States without a parent. Dr. López's book is also relevant for those thinking beyond, thinking about intergenerational consequences of state punishment beyond the immigration system. For example, those who study mass incarceration. So here I'm thinking of people like Kristen Turney, who examines the consequences of criminal justice contact on family life, or Holly Foster and John Hagan, who offer this multi-level social exclusion framework to capture how the state's targeting of an individual has impacts that reverberate to the family and more broadly to communities and to entire social groups. So I see Dr. López's book contributing to these broader conversations that we're having in and outside of the study of migration. And this is really a book about the expansive and very deep reach of the state's coercive power and the intergenerational implications of this power for social integration. So given those contributions, the question that I have related to them is one that's actually rooted in policy. When I was finished reading the book, I had learned so much about family reunification and about people's experiences with these laws, and I was convinced that the laws needed to be amended, and because they cause harm to families, especially working class and racial minority families. And Dr. López provides some very clear policy recommendations in the end. So I was very encouraged about that. But my question is, of the legal changes that you talk about in your book at the end, what do you think would make the most difference to mixed status families, given what you know about your respondents' experiences, and what do you think seems most achievable, given all of the challenges that go along with reforming the US immigration system? So this is a question about, imagining that President Biden taps you on, the shoulder and says, help Congress rethink family reunification law. And of course, Congress says, you can do one thing. What is that thing, and why is it so important? How would it change the lives of people who, are people like in your sample? So that's a broad question about the practical implications given those contributions. The remaining question is more specific and was prompted mostly by reading chapter 3, where Dr. López uses a metaphor of a poker game to show how family reunification outcomes can vary for couples based on how they play their cards. So where their cards are their qualifications for family reunification, things like personal income, family structure, the existence or not of biological children, educational level, all of these things that the state uses to evaluate the worthiness of these couples for reunification. So I thought this chapter was just a fascinating look into agency and strategy on the part of couples. And it shows that based on how they play their cards, the couples can win, even when the law on the books would predict that they wouldn't qualify for reunification, or that they can lose, even if the law on the books would predict that they would win. So the question here is about the role of the state in family reunification poker. I was really tempted to continue with the metaphor of poker, but I don't know the first thing about poker. So I wanted to say, what about the dealer or something, but I don't think that would have worked. But I know that there's a story here about bureaucratic discretion. I just don't know what it is. So many of us are familiar with the image of the capricious immigration bureaucrat that uses their discretionary power in somewhat unpredictable and undecipherable ways. But in this chapter, you remind us that couples are also able to exercise discretion in the amount and type of information that they share on their application. So this is an agentic view of that process. So in this explanation that you provide, the bureaucrat does not appear at all indecipherable, but rather as a predictable implementer of laws on the books, where to win at family reunification poker, all couples have to know is what the black and white letter of the law states, And then they can strategize based on that, because the bureaucrat is only going to do what is on the books. So I'm wondering which of these two admittedly overgeneralized bureaucratic images resonate more with your respondents' experiences playing poker. Are US CIS bureaucrats really that predictable, like the image that I took away from the chapter, or are there examples of that capricious bureaucrat, which would provide some disconfirming evidence of those dominant patterns that you identify in this chapter? I think that's a really important question because it has implications for how we think about the state's role in managing migration, has implications for, you know, the implementation of immigration law. And I'd be really interested to hear your reaction to that. So again, I want to congratulate Dr. López on a phenomenal book. I really enjoyed reading it. It was a real treat, and I look forward to the discussion. Thank you.
Okay, Irene, thank you very much. So terrific comment. Jane, floor is yours.
Thank you so much, Dr. Vega. It is a joy to hear these comments and have you thinking deeply about my work. And I met Irene for the first time when we were both still grad students, and I think I had barely decided that I was going to do my dissertation research on this topic, and I felt so encouraged by Irene then, and I'm so grateful to feel your encouragement now and to have you make these connections for me. It's really great. Since I'm thinking about poker right now, let's start with your second question first. And I think what I would say is, first of all, I'd like to talk with you separately about getting permission to speak with people who usually won't let you speak with them, because I would love to interview the people who conduct these interviews. The USCIS officers who are conducting interviews both within the US and at consulates across the world, who are tasked with this responsibility of evaluating whether or not a relationship is legitimate or potentially fraudulent. And I will also admit that there is a selection bias in my research, which is that all of the couples that I interviewed are legitimate couples. I didn't interview any couple that got married specifically for the purposes of getting immigration, getting access to permanent residency rather than for the purpose of creating a family together. I think though the data shows that actually the rates of fraud are quite low. So what I think I would say is that for most families, there are clear things that disqualify them that are written into the law that they can't change. And so that just automatically disqualifies them. And there's not a lot of subjectivity from that individual person who's interviewing you. For families where the spouse entered without authorization, they have no, unless they can get this extreme hardship waiver, right? They just are automatically rejected. Their claim is automatically rejected. So the subjectivity comes in more in two different ways. The first is in the interview, right? When they're evaluating this portfolio of evidence of your relationship, right? And you're putting all the cards out on the table. And for couples that have been together for longer periods of time, who have children, who have these other things that satisfy those standards, I think again, there's less room for the officer to say, actually, no, I see you have children together. I see you've been married for 8 years, whatever, but I don't think that your relationship is legitimate. So the question of the legitimacy, I think, comes in more when a couple is applying for family reunification shortly after they've married, or with a shorter period of time that's established in their relationship. But that permanent residency is conditional anyway. And so I think what happens a lot is they say, okay, now you've got, in 2 years, you're gonna have to reapply to have the condition on your permanent residency removed. So you better still be married. You better maybe have some kids by then, or do something else to prove to us. And so I think there's this way where even that subjectivity, there's a built-in way that they can say, okay, we're going to give you temporary permission, but you're going to have to do a little bit more work to prove to us. So in the couple's experiences who I talked to, who had gotten to the point where they had been interviewed, I don't think that they felt like there was that much subjectivity with regard to that person who was interviewing them. I think they felt like they were measured by the book, right? Once they got to that point. But a lot of couples couldn't even ever get to that point because they would be disqualified. I will say though, that like the government changes the laws a lot. Even just when our family reunification application was under review, which took 2.5 years, the minimum income requirements, thresholds changed. There were different requirements about like health insurance and all these, like the law was changing. It's changing all the time, right? And in that sense, it does feel like even if you have put together very carefully this hand to put together a winning hand, that the rules could change in a way that what you thought would win no longer would. I think the other place where subjectivity does come in, but we don't, it's not like an interview, and so we don't see this, is in that hardship waiver application. We don't really know what counts as extreme hardship, and there's a lot of subjectivity with who gets it on their plate, and maybe the previous hardship application that they read right before yours, and oh, they seemed like they really had it bad compared to your situation, right? And so I'm not going to grant that. But I haven't been able to get like an inside view of that experience at all. So it's something that I would love to follow up on. And I think, you know, that's a huge part of this like black box of immigration law enforcement that we don't have much insight into in terms of how things work, and the extent to which, like you said in this analogy, the dealer has agency in terms of when they play their cards, or if they hold trump cards to, you know, like beat other families. With regard to your question about the policy changes, and I have a slide with some of the things that I suggest in the book, which I will just share really quickly. So, and then I have kind of like a big picture proposal that I'm going to skip right now because I don't think Congress would be down with my proposal, which is to treat families based on the rights and status of their most qualified, or like their member with the most rights rather than the member with the least rights, but based on these different recommendations. So the one that I think that would make the most difference, and if you'll allow me, Irene, to bend the rules a little bit with your requirement, I'm going to throw point 1 and point 4 together. No, point 1 and point 3 together, which actually are part of the same law. So if we repeal the bars to entry, or I would recommend for everyone, but at least for the spouses of US citizens, including those who entered without authorization, and also get rid of the permanent bar for people who are found to have made even an like unintentional fraudulent claim of citizenship. I think those are the two changes that would make like the biggest and most meaningful change for mixed citizenship couples as a whole, and give many, many, many more families the opportunity to experience all of the positive outcomes that I find for families that have receive family reunification and are granted family reunification here. And with regard to which do I think is the most achievable, I'm going to refrain from making any comments or statements about the state of our current like congressional situation. But I think, I don't know, I think all of these are possible. And I actually think that like repealing the bars to re-entry and even the minimum income thresholds, which also all 3 points 1 through 3 also all came from a 1996 law. I think those changes would actually be really easy to make and wouldn't be like politically difficult to make. Maybe creating something like points 5 or 6. I think I don't think they're controversial at all, but I think that because it would be like creating a position or, you know, like an opportunity that doesn't already exist, some people are going to push back more than if we say, how about we just go back to the way things were before, I think that might be an easier step to take. So those are my thoughts. But I really feel like these are really simple steps. All of these changes could very easily be made, and I don't see them being really politically controversial, but that's just me.
Okay, all right. On that note, when we open it up to discussion, it would be easiest for me if you would use the raise hand function. Hold on. Oh, 1 second, I'm trying to see whom I see at the moment. So I don't see everybody. Let's see. Or send me in the chat a question. Not, okay. I'm not seeing anything. All right, now I don't know whether that's it's a communication problem or whether in fact nobody has a question, which would surprise me. So, all right, so if nobody has a question, then let me abuse him. Oh, David, go ahead.
Hi, yeah, so thanks very much for that, Jane and Irene. So my question is following up on what you just said about how you think that your proposal is not particularly controversial. And I'm wondering, from an institutional perspective, what do you think is the barrier to that happening if it's not something that would fall along a classic partisan divide?
That's a great question. So from what I understand, and this could be wrong, I don't think that mixed citizenship families have been considered specifically with regard to immigration policy changes. I think, and I agree that there are there's a lot of potential problems with kind of sectioning out different groups of people, maybe people who could be deemed as more worthy within like immigration reform. And so I think there could be problems, but if we're just saying, if I was just asked, like, how would you help mixed citizenship American families today? I think, you know, there are policy options that could change. I just don't think that many of our congressional leaders have ever thought about that group in particular or saw them as like a big enough group to be worthy of consideration, even though like more than 4 million households in the United States are mixed nativity households with members with different citizenships, born in the US, one born in the US and one who is not. So I think that's part of it, that they've never just said like, oh, we can make these tweaks to the law that would help these families and do it outside of some bigger comprehensive immigration reform or a bigger policy like that. So I think that that's part of the problem. I do get that all of these issues are very highly politicized, and I think immigration in particular, I think a lot of people kind of like have a gut reaction to it, but if I was able to sit down and talk to them about it, I think maybe I could paint this picture of why politically they could make a really strong claim that they're strengthening American families and supporting American families. And like with repealing the bars to reentry policy, only some mixed citizenship families are subject to that right now. Only those with partners who did not come in with a visa. So if you come in on a visa and overstay a visa, you're not subject to the bars to reentry. But if you come in without a visa and marry a U.S. citizen, you are. And so I think we already have lots of evidence to show that some people who are not being subject to the bars to reentry, but technically could be, are doing just fine, and our country's benefiting from that. And so it would be a really easy case to make that like maybe we should just expand the people for whom those bars to reentry are waived if they don't eliminate the bars altogether.
Okay, terrific. So I still don't see any hands up.
Oh, there is one from Vincent.
Okay, go ahead.
Oh,
You
hi.
could also, if you open, I could see you, but most people have their cameras closed. Who's the questioner?
Hi, my name is Vincent. I'm a student at MSU. So I know this is what you sought to do or wanted to, it may be out of this project scope, but how do you see the experience of same-sex couples differ from what you're studying, given that gay marriage is legal, and so technically legal-wise, that same-sex couples can form families, but then homosexuality is, well, despite being legal, is still kind of seen as the alien citizen in the US. So given that disadvantage, what do you see, how do you see same-sex couples experiences differ from heterosexual couples?
Thank you so much, Vincent, for that question. So I had one same-sex couple in my sample, but unfortunately was not able to find any other same-sex couples to interview. And I think particularly kind of getting back to Irene's question of subjectivity, I think that same-sex couples face higher bars to, or like barriers to proving the legitimacy, the validity of their relationship, just based on the fact that we have kind of less clear norms around, and I think that's where a lot of like assumptions and individual perceptions are going to come into play when individual USCIS officers are evaluating the couple's applications. Since 2013, same-sex couples have been eligible for family reunification, and so like at least the way the law is written, they should have equal access to family reunification in comparison to heterosexual couples. But I think that's where these questions, these small spaces of subjectivity would come into play in making things a little bit harder in terms of proving the legitimacy of their love and relationship. I mean, even other things like having children, obviously it's like a more complex bureaucratic process, but I think also the focus within US immigration laws right now on biological relationships would also complicate kind of how shared parenthood of a child is seen as like valuable or evidence of the legitimacy of a relationship in order to be approved.
Okay, terrific. I still don't see anyone else. All right, so then I will abuse the privilege of the chair to ask a question, and I have to admit will be, and I hope you will excuse me, a little bit obnoxious. But I guess, so to begin with, if you look at the categories under which persons are admitted as legal permanent residents of the United States, what you see, of course, is that the bias is overwhelmingly towards relatives, and overwhelmingly towards the immediate relatives of citizens. So there's no numerical limitation on the immigration of the spouses, minor children, or parents of citizens, and that in fact, if you look over a 10-year period, that averages around 450,000. That's a big number. That's close to 50% of all legal entries. And about 275,000 a year are the spouses of citizens. So in a way, my first question to you is, okay, what's relative to that flow? How many people are caught in this problem? What fraction of the potential immediate relatives, spouses of citizens, are actually encountering these very difficult obstacles, as opposed to what a year, 2, 3, maybe even 5 years of difficulty, but something that very significantly disrupts their life. And insofar as that, I mean, it seems to me the question of the relative size of this population is relevant, and that if in fact, I don't know, you're talking about 10%, 15, 20%, well, that's one thing. But if you're talking about 5 or 2, which could still be a large population, quantitatively, relatively small, then should we expect, just given the overall size of the population, there are going to be frictions, there are going to be problems, things aren't going to work out. That's kind of question number one. Question number 2, and that's related to what I just described about the size of the inflow of the bias towards the relatives of citizens is, this is the weak link in migration control. I mean, you know, if you took the standpoint of a policymaker, I mean, imagine U.S. immigration law were organized in ways that would make it a little bit more like Canada, right? So that the goal is, how can we structure immigration so that it works for the U.S. economy or contributes to U.S. economic growth? You wouldn't increase opportunities for citizens. You would, I mean, in all likelihood, you would make it easier for high-skilled immigrants to come in. You'd increase temporary flows of low skills, and you put other people at a lower priority. So in a way, what you have is, I mean, that's again another way of illustrating the bias towards citizens. But it also means that it's inevitable that bureaucrats are going to be trying to curb that, to control that, that portion of the flow that in a way is the least hindered. Now, you know, you're describing the obstacles that you are pinpointing are those for which that are inscribed in law, so that have the greatest impact on persons who have entered without documentation, which is a situation where the bureaucrats have less control. But there are all sorts of situations that are taking place outside. I mean, especially marriages that are contracted outside the United States, where undoubtedly the discretion is on. Oh, but now this is my obnoxious point. In a way, it seems to me you're defending the people. You're arguing for an increase in the. You're arguing for a further bias in the direction of the people towards whom the system is already most heavily biased. I mean, relative, if we accept the fact that we live in a world of controlled migration, and let's say we have a more or less fixed limit of immigrants, 1 million, 1.5, and you know, whatever expansion goes to one group has negative consequences for the other. So wouldn't it, I mean, from a strictly humanitarian standpoint, let's say, or cosmopolitan humanitarian standpoint, we're thinking about the globe overall, think about this as an issue of global stratification. Every US citizen is very, very privileged. Why give the citizen more privilege? Wouldn't it be better to say, okay, you know, some of you citizens, too bad, you know, things don't work out, but it's much more important that we create greater opportunities for refugees and asylees. I mean, they're suffering much more. So some citizens have to lose, but on average, if we think about migration as an aspect of the global stratification system, and we want to do just a little bit to try to create greater equality, we're not going to make the things better for the citizens. We're going to make things better for the least privileged non-citizens whom we can admit. Right, so those are my 3 comments. Sorry for being at the tail end.
That's okay. So to your first point, I was trying to find, I know I made a calculation somewhere, I couldn't find it. I was looking for the footnote where I had it, I couldn't find it. But I think it's somewhere between over 1 million American families that are living in the US that have been eligible for have been here long enough that the non-citizen spouse could have qualified for citizenship and has not yet naturalized, right? So, I mean, it's really hard to calculate how many people are being affected by this, plus, you know, many more families that are living outside of the United States as well that we don't have any numbers about, and that the country just kind of has basically stopped caring about as soon as they're off our territory, right? So I think it's a pretty significant number of people. To kind of get to your last point too, is that I'm okay with us deciding that we want to prioritize different people's needs or values. But I think that as long as we're going to say that your citizenship does give you this, I don't know if privilege is the right word, right? But does come with it some kind of offer of family reunification, then I would say, why don't we treat citizens equally? And so part of what I want to point out is that I think that most of us work on this assumption that that things are working out for citizens anyway. But from this experience that I have, it's not working for all citizens the same way. And what I find is that it's very much dependent on socioeconomic status. And so I'm not sure if we want to help some citizens, if we should say, well, okay, the rich citizens should be the ones that win. And I'm sorry, poor citizen, if you're the one who loses out. So I agree that there are lots of different ways that we could be addressing this issue, but I think that if we're going to focus on citizens and we're going to claim that citizens have certain rights to family, then I would argue that we should be more consistent in the way that we apply those laws. And, you know, maybe we are being helping the people who have the most already and should be focused on others. And that's like, I will take that point. But I think that within, if nothing else, I want to point out that we're not actually helping all citizens, and that both with regard to citizens and non-citizens, we're helping those who are most privileged more than those who are less privileged within those different categories. I am forgetting the gist of your other comment. Will you remind me again? And then I'll.
I was just making the point that if you think about marriage migration as the weak link in migration, inevitable that there are going to be efforts on the part of those people exercising discretion to try to clamp down on it.
Yeah, I just, I don't know. I feel like in most things, we are a highly punitive people, and we're more interested in pushing lots of people to jump through many hoops in order to prevent that potential of someone trying to break the rules. But I think there are other approaches that we could take, like giving people, and approaches that we already take. So if you're adjusting from overstaying a visa through your spouse to permanent residency, you are able to access work authorization. You can have a travel document, so that advanced parole, so that you can leave if you need to leave the country. And so we already offer that to some people, but not, for example, to couples whose applications are being processed outside of the US. They have no access to the US or to being able to start their lives here while they wait. And so I think we have lots of evidence to show that when we have given people the benefit of the doubt and given them some opportunity to continue to establish themselves and their families in the US while they wait for their applications to be approved, that things work out well for them and things work out for the country too. And as far as I know, and there's not that much data on marriage fraud, just kind of a lot of people saying what they think that they know. But I think that there are a number of fail-safes built into the process, especially for families who are under this conditional status, that the government has opportunities to change its mind if it realizes that these relationships aren't legitimate, or there's a problem where they don't want that person to have legal status in the country anymore. But I think that our country would benefit a lot from giving families the benefit of the doubt as they're working through the reunification process, rather than creating more barriers and more challenges for families while they wait, whether or not they're legitimate. So I think, I don't really buy the argument that we need to make the vast majority, life and love and stability, that much harder to access for the vast majority of these families who are otherwise really important contributors to our society, because of this unprotected border of marriage fraud. I just don't think the numbers support that as the true immigration threat to our country. But I get that because it's one of the few subjectively based relationships that is included within our immigration structure right now, which is so dependent on family relationships for accessing legal status, that can make them feel really uncomfortable, I guess. I just don't think there's that many numbers to support this as like an issue that we should be investing so much money and time and like difficulty into a process when the country benefits so much more when families are given more opportunities and tools to succeed rather than setting them up for failure.
Okay, I wasn't, I mean, I wasn't advocating the current policy. I was just trying to.
Yeah, no, I mean, I think it's a really good question. And again, part of like our lack of knowledge of how many numbers, like how much this is actually happening, I think allows it to build up in our minds to this much bigger problem than it actually is. And if you read the congressional discussion about the international marriage fraud agreements, amendments, where these things come from, like they're talking about it being this huge issue and they're so worried about it. And but it's because nobody actually is collecting data on it. And I think they benefit from not showing how rare marriage fraud is.
Okay, thank you. So now two quick, let's Molly Fee, and then we'll go back to Irene, who raised her hand, I think. Yeah, Molly.
Hi, Jane. First of all, congratulations on the book. I'm very excited to get a copy and read it. So one of the questions I had was whether, it's sort of a two-part question. So are there other national models that you think work in a less punitive way that ameliorate some of the issues that your respondents encountered? And did some of the families who had to live out their lives in other countries because they weren't able to do so in the US, did they find similar policies or effects of disintegration in these other countries? Or did they encounter immigration systems that welcome them based on the fact that one family member was a citizen? So sort of how did other national models of family immigration shape the experiences for those who did have to go elsewhere?
Thank you. I will say that I have not done like a systematic examination. I need to write this down as like a future project of just systematically looking at how other countries are dealing with families and what their policies are with regard to family reunification with the spouse. So I'm gonna make a note of that. But so all of the families that I interviewed had the non-US citizen spouse had citizenship in Mexico, El Salvador, or Guatemala. And so in all of those countries, basically like there is a policy, but all of the US citizen partners could go and live in those countries, and at least like for a certain period of time while they were getting things, like it wasn't easier. I won't say easier because bureaucracy in all of these places had posed its own issues, but the Americans could get into their country and start living there and then figure out their status later in ways that just like travel as a non-US citizen into the US is more complicated than going the other ways. And so like, at least on an initial level, they were able to live as a family together in those other countries without facing the same problems. And there was some path for them to be able to get family reunification, so like get a permanent status and even citizenship through those, through their partner in those other countries. But I should do a more systematic evaluation to see what other countries are doing and how it's working. I think just for these families, it just wasn't really an issue. And a lot of the US citizen spouses living with their partners outside of the US didn't get dual citizenship or even seek like a dual status, even if they qualified, because it didn't feel as bureaucratically or even symbolically important for them as kind of the converse of that. What I will say with regard to your question about integration or disintegration, all of the families who experienced deportation or forced, or voluntary removal, right? Also experienced a level of disintegration in their community where they were living outside of the US. And in part that came from being forced to move somewhere where neither spouse had many networks. And part of it just came from how evident their exclusion from the US was in their daily lives. And a lot of them talked about how people immediately could say like, oh, you're an American, and could see them as other, but they had been told by the US government, you're not an American. And so this conflict of having an identity that was being directly opposed by the US government, and then going somewhere else where other people kept wanting to put that identity on them and say, you're different from us, you don't really belong here. And struggling with, where do I belong then if I can't be here and I can't be there, or I can't be myself. And so I didn't find that, for example, with families who chose to live outside of the US, but who had the ability to move back and forth, or who could qualify to acquire legal status in the US as a family. They really did experience this full level of integration in both of their countries of membership, and built strong relationships and traveled regularly between countries, even if they were living outside of the US most of the time. And I was pretty surprised by that, because I think assimilation and integration literature would suggest to us that the more you belong in one place, the less you're likely to belong in the other place. But instead, I found that enhanced integration in the US helped facilitate greater integration for these families as a whole outside of the US, whether they were living in the US or outside of the US too.
Okay, excellent. Irene, do you want to return to the discussion?
Yes. So I have a comment that leads into a minor question and then a larger question. As someone who grew up on the border myself, some of the stories of these binational existence of many of these mixed status families were familiar to me, as someone who kind of lived that trans-border binational experience myself growing up. And you talked about the social disintegration that occurs following forced removal or voluntary removal, and really a disintegration from, so here I'm thinking of people who went to live in Mexico, really disintegration from that setting too, even though they have formal membership, or one of the people have formal membership. So one question is, what proportion of, I think you said 4 million mixed citizenship couples go do this kind of binational experience that you identify here? Is that pretty common? Because I actually think that it almost, by doing this study along the border, it almost underestimates the impacts of these kinds of policies on the way that people live their life, right? Because you still have families that can sort of see each other. They're doing, all kinds of really difficult things in order to be together, but at the end of the day, they have that option, as opposed to distances that don't facilitate that living together piece. So I wondered about the proportion of the 4 million, mixed citizens that do this binational thing. And then, because I think it underestimates it when you do it on the border. And then the other question is, and I think you've talked about this with Roger and in the book, about how there are really class-based preferences that are built into the US family reunification system. And that really it's the more privileged, not the working class, but the more educated citizens or migrants even, that are able to succeed at, the poker game. So thinking about how families strategize differently, did you find that those more highly educated families, or the ones that are more resourced, were they more likely to have legal representation? So what difference did that make? And two, were they more likely to take a more active approach to the poker game? Because if so, then I think there's a story here about cumulative advantage and disadvantage that relates to these class-based preferences.
Thank you. I don't know at all what percentage of families are kind of splitting things. I will say though that clearly it's something that US citizens with Mexican citizen spouses can do, but that US citizens with like Guatemalan citizen spouses can't, right? And so that kind of trying to make things work across borders is definitely a country-specific option that lots of families don't have. And you know, if your partner, even if your partner is deported to like Europe or Asia or Africa or whatever, like it's not, or even South America or anywhere else, basically, except for like Mexico and Canada, like it would be really hard to make that cross-border experience work. And I think even for families where they do kind of, the US citizen can maintain a relationship in the US, but also live with their partner in Mexico, there's still a lot of disconnect that comes from that. So I don't really know what that is, but I was also surprised to interview couples who are like splitting their time between Indiana and Mexico City, you know? So I think it's not just what's happening right on the border, but also for people who have permission to travel freely between both countries. I think there's a lot of extensive networking and building of ties and work and relationships happening deep inside both countries and not just in the border region. But I'd love to get access to more data, and it's been hard to have incomplete numbers or like no data at all. It also made me think of Roger's question, which is like so many US citizens are getting family reunification with their spouses every year. But what we don't know and what's not released with the numbers is how many applications are denied. And so it's really hard to know, okay, there might be like 400,000 couples that are getting this benefit every year, but we don't know, was it 5,000 that were denied, or was it 50,000, or was it 500,000 who didn't get it? And we just don't have that, or I haven't found it. If someone has access to it, please email me. With regard to this class-based preference and cumulative advantage, it's interesting because I think it depended on, I think some families that could hire a lawyer or whatever did everything right away, and going all in right away can be can get you into trouble, especially if your legal advisor like isn't that great. And I think a big problem is that like the quality of legal advice from immigration lawyers or people who like are notarios or, you know, like whatever, like claiming to have this knowledge, there's a pretty broad spectrum, and it only takes like following one bad piece of advice to get you stuck in this like 10-year plus purgatory of being barred as a family from the US. So I do think that in many cases, they did have the advantage if they could pay for a lawyer. It's interesting though, you know, these couples, even if they had more education or came from middle class or upper class families, they were still usually like young couples when they were getting married and going through this process, and so didn't have $5,000 to $10,000 just like sitting around to pay for a lawyer. And so a lot of them thought like, I know how to fill out forms, right? And did it themselves, or asked, you know, a friend for advice, but didn't seek legal counsel, and that got people into trouble as well. And so I think in certain ways that having this like socioeconomic advantage, if in couples who didn't know that they needed to be like afraid of or so careful with the law, like didn't know how much was riding on getting everything right, I think sometimes lean too much on their own like knowledge and ability when getting that expert advice could help. So yes, I do think that it contributes to a cumulative advantage, even just like having a friend who's a lawyer who says you should talk to a lawyer, you know, those are all things that I think helped people who had socioeconomic advantage to know that there was a game that they should be playing at all, and that strategy actually mattered, who knew that they didn't have to apply right away, that they could wait, who knew all of those things, it's not necessarily knowledge that is equally distributed across groups. But I think like actually knowing another couple who had been through the process before could be even more valuable than having the like economic means of paying for a lawyer, just by learning from someone else's like hard-earned experiential knowledge of how the process works.
Okay, well, I'm afraid on that note, we're going to have to bring this session to a close, but I want to thank Jane for a terrific presentation, congratulate her also on this wonderful book, thank Irene for a very insightful comment, thank all of you for joining us today, and to remind you that the next week is a didactic workshop oriented towards graduate students that will be led by Professor Marjorie Orellana, and that we will meet here again at the same time, same place on December 3rd for discussion of two very interesting books on refugees and asylum. So on that note, bye-bye everyone, have a great weekend, and looking forward to seeing you again soon.